Today is Wednesday, March 20th, and I'd like to call to order this meeting of the Brookhaven City.
Turn the mics up.
Hello? Let me
all on?
Yes. Can you hear me now?
Yes.
Okay. Today is Wednesday, March 20th.
Louder, please.
Do we have any way to turn up volume on the microphone? All right, is that better in the back?
Yeah.
Okay. Today is Wednesday, March 20th. I'd like to call to order this meeting of the City of Brookhaven Board of Zoning Appeals. I'll note for the record that all board members are present and on time. The first order of business is the approval of minutes. Howard, we don't have any minutes for this meeting, correct?
Yeah, you'll have both sets of March minutes at your regular April meeting.
Okay, so we do not have any to approve at this time. Second item on the agenda is our organizational and procedural items. And we need to discuss our proposed rules of procedure for the Board of Zoning Appeals. So I'd like to open the floor for discussion among the board about the rules and procedures that you received and see if we have any discussion about those. Glenn, did you have a question about it?
I did. It's with regards to section 15 involving voting. I'm not sure, and maybe it says this, but it's not explicit, but in the event that there was a tie, my sense is that would mean that the motion or whatever's before us fails. And I want to make sure that is that correct?
Yes, sir. You're also adopting as part of this rules and procedures. You're also adopting as part of these rules and procedures the Robert's Rules of Order. And according to that, if there's a tie, the motion fails automatically.
Okay.
Still can't hear Robert's rules.
Okay.
All right. Any other discussion?
Yes, I have a comment on section 14. I would like to make a motion to add a sentence of clarification after the fourth sentence ending in "a board member should not speak at a meeting until he or she has been recognized by the chairman." To add, notwithstanding the foregoing, it shall be understood that individual board members may ask questions of applicants, parties, counsel, and other speakers.
All right.
Yes. Did we have a motion yet, or is that?
Yeah, that was, I moved to add that sentence in section 14 of the rules after the fourth sentence.
I'll second that motion. All right, any discussion on the motion? All right, seeing as how there's none, we'll call it for a vote on the motion to allow the amended sentence. Can you read that sentence one more time?
I'll read it again. Notwithstanding the foregoing, it shall be understood that individual board members may ask questions of applicants, parties, counsel, and other speakers.
Okay. All those in favor of adding that to the proposed rules signify by saying aye.
Aye.
Aye. All those opposed? All right, the motion so passes.
Thank you.
Is there any other discussion about the proposed rules? Someone like to make a motion that we adopt the rules?
As amended.
As amended?
I'll move we adopt the rules as amended.
I second.
All right. Any discussion? All right. All those in favor of adopting the rules as amended signify by saying aye. Aye.
Aye.
All those opposed? All right. The amended rules have been adopted. All right. I'd like to take a minute to read a preamble of the Zoning Board of Appeals, just so everyone understands the.
You do the vice?
Oh, I'm sorry. One more item. Seeing as how we've adopted the rules of procedure, I think at this time we need to go ahead and elect a vice chairman pursuant to Section 5 of the approved rules and procedures. Do I hear any nominations for a vice chairman?
I would like to nominate Jed Beardsley.
Any second?
I'll second that.
All right, any discussion? All those in favor of electing Jed Beardsley vice chairman of the Zoning Board of Appeals signify by saying aye.
Aye.
Aye. All opposed? The motion passes. All right, moving on. I want to read a preamble for the Zoning Board of Appeals just so everyone understands exactly what the purpose of the ZBA is and what our duties are defined as. The Zoning Board of Appeals is charged with the responsibility of granting variances, ordinance requirements after determining whether there exists an undue hardship upon an applicant if a variance is not granted. In determining whether or not to grant a variance, the board shall apply the criteria specified in section 27-916 of the zoning ordinance to the facts of each case. The board further hears applications where it is alleged that an administrative official erred in a final order, requirement, or decision based on or made in the enforcement of the zoning ordinance. The Zoning Board of Appeals does not create zoning, nor can it change zoning. The board has no authority to grant variances for use, density, or height. Matters brought before the Zoning Board of Appeals are to be concerned only with variances from development standards placed on property by the zoning ordinance. Final decisions of the Zoning Board of Appeals may be appealed by petitioning the Superior Court of DeKalb County within 30 days after the decision is rendered. All right. Moving on to old business. We do not have any old business, so we'll begin with new business. The only item on our agenda tonight is item AA 13-031, formerly DeKalb County case number A-13-18379, Catherine M. Zickert and Dennis J. Webb, Jr. of Smith Gambrell Russell, LLP, located at 1230 Peachtree Street Northeast, Atlanta, Georgia, 30309, are representing Teresa Tomlinson, 3770 Peachtree Road, LLC, et al., the applicants for the following: an appeal of an administrative decision to deny approval of an overlay certificate of compliance and a pending application for a land disturbance permit. The addresses of the subject properties are 3770 and 3804 Peachtree Road Northeast, Atlanta, Georgia, 30319. The tax parcel numbers of the subject properties are 18-239-02001 and 18-239-02002. All right. Let's get a summary of the staff recommendation on this proposal to begin with.
I have a point of order first, Mr. Chairman.
Okay.
I see a court reporter present. Could we have that person identified for the record so that any transcripts of this meeting can be presented to the board and to the city?
The court reporter was actually hired by Ms. Dunleavy and I, but we're happy to share the takedown with the city if they want to copy the transcript.
Okay, could we have her card?
We already gave it to her.
Okay, good, thank you. The second point of order would be to discuss the time we're going to give the applicants at the podium to present.
Yeah, I was going to let the applicants request more time if they so desire.
What's the standard?
10 minutes is the standard that we've adopted in our
That's what I thought. Okay.
Right.
I don't think there's any way either one of us can present what we have to say in 10 minutes. So
Okay.
we would ask that you give us the luxury of allowing us to exceed that limit. I promise you, on behalf of us both, that we will keep it as short as we can.
Okay. Do I hear a motion to extend the time?
I move to extend the time to 20 minutes to each side.
That's still not going to be enough for our position. Linda?
I believe that will be sufficient for our position.
It's a total of 30 minutes is the
Fairly
motion.
efficient.
Is it 30?
A total of 30 minutes for each side.
Okay.
All right. Any discussion? Or is second on that motion? To extend it to 30 minutes to each
Second that
side?
motion.
All right, any discussion? All right. We have a motion to extend the time for 30 minutes for those for and against the case at hand. All those in favor signify by saying aye.
Aye.
All opposed? Okay. Please let the record note that we've extended the time period to 30 minutes per side, and if you could keep track of that for us, I'd appreciate that.
Something's wrong with the
All right.
audio.
Would staff please give the board
30,
a...
not 45.
I think we know something about this.
Howard, you only get 4 minutes.
I'm gonna work on y'all, because we can't hear you in the back at all.
Please.
Okay.
And get somebody sicker, you're going to need to hold the mic.
I will.
Good. All right, thank you.
This lone item of new business this evening stems from a 2012, December 2012 denial. Sorry, I'm getting a little bit of feedback over here.
I know. Give me a second.
Oh, okay.
This is an estimate.
From a December 2012 DeKalb County staff denial of a request for a certificate of appropriateness and subsequently a land disturbance permit. The applicants made application to the county to begin a new project at the intersection of Bel Air and Peachtree. At such time, the evaluation from the staff at that point was that the application submitted was incomplete and non-compliant. In your packet, also in the record that we have here, there was an analysis done by DeKalb County staff why the finding was that it was incomplete and non-compliant. There are a number of reasons, pieces of information that were missing, and there were some pieces of information that did not meet the terms of the code that was in place at the time. So after going through the record, we found that there hasn't been any finding of there being any erroneous finding of material or fact on the portion of the application that was reviewed, and that the administrative official at the county did not act in any arbitrary manner because they compared the application against the code. So we haven't found any reason that the staff's finding was incorrect, and therefore recommend that you affirm the DeKalb County finding from 2012.
Okay. All right. Well, since this is a public hearing, I'll open the public comment section. I'll start with the applicant and let you begin.
Thank you, Mr. Nama, members of the Board of Zoning Appeals. I'm Kathy Zickert with Smith, Gambrell, and Russell. I represent various members of the Tomlinson family who have lived in this community since the 1930s. Many of them still do, and a number of them are with me this evening. I want to begin by telling you that what your staff has characterized this appeal as is incorrect. We are not appealing the failure to issue either a certificate of appropriateness or a land disturbance permit. What we are appealing is the failure of DeKalb County to process it, which is where it belongs, number one. And number two, an interpretation by DeKalb County about certain elements and the reasoning as to why they refused to process it. But first, I'd like you to be familiar with the site. I know you drive past it a lot, but it makes a little bit more sense and in context, I think, if you look at some aerial photography. This is really high tech for me. If I blind someone, I apologize in advance. This is the tract in question. That's Bel Air Drive, that's Club Drive, and of course that's Peachtree Road. There are two tracts. One is actually here. That is the smaller of the acreage, which is in DeKalb County. The second is here, and that is partly in DeKalb County and partly in Atlanta. So we're not talking about this tract, and this tract is the two tracts that make up the site. This tract is all 3770. This tract is all 3084. So we have one lot that is bisected by the City of Atlanta line, and it is in fact still one lot, as I will demonstrate with the next slide. Shauna, slide 2, please. This is the plat of the City of Atlanta piece and of the DeKalb piece that is of record in Fulton County, and it was filed back in the 1950s. You can see that, yes, there is a county-city line in the middle of it, but it has always been platted as one lot, and it has always been developed as one project. In fact, that county line bisects one of the existing buildings that are on the site. So to claim that there are two lots here, which is one of the underlying premises of what the staff ruled in DeKalb County, is simply incorrect. Next slide, please, Shauna, is slide 4. We don't know how to do PowerPoint in our office. This is a survey of the tract, which shows the exact same thing. This is one lot. This is a surveyed lot, and it has a City of Atlanta line that runs through it, and again, as I said, runs through the side of the property building. Slides 5 and 6, please, Shauna. This is what we wanted to put on this property. It is not a 9-story building. It is not a 7-story building. It is a 6-story building on top of a parking deck with 176 units. And on the front of the property, we had placed townhome units effectively because that's what we thought the overlay called for. You can see that this is the general design, and you will see that this area is labeled park. What that is the City of Atlanta piece. And this perhaps will give you a better idea in terms of the site plan for the property of what we intended to do with that green area and always intended to do and expressed as what we would do from the time we started the formal process here. Let me give you a little bit of the history on this tract, if I might, please. In August of 2012, our broker, Rob Jordan, met with David Cullison in DeKalb County specifically to discuss what could be built on this tract. He was told several important things. He was told that it could be developed either in Atlanta or DeKalb or both. He was told it was totally appropriate to do it for a high-rise, high-density, 6-story building. He was told that buffers and transitional height plans, would be measured from the property line as opposed to the City of Atlanta line, and that what they were proposing to do with the tract was perfectly okay. He did suggest, however, that the broker should talk to Cedric Hudson, who is another planner in DeKalb County, to talk about whether we should have an intergovernmental agreement between Atlanta and DeKalb to deal with that piece. He met with Cedric Hudson. Hudson said the easiest thing to do is leave it out. Leave it as your buffer. So that's what we ended up doing on the final development plan. And this is hardly the only property which is bisected by the city-county line. 7 and 8, please, Shauna, 7 first. This is Lenox Park. You can see where I think the property, I need my glasses badly. The property is bisected. There it is, that red line is City of Atlanta and DeKalb. You will notice that the project was developed as a whole because this was all one development, and they entered into an intergovernmental agreement, and they weren't required to have separate setbacks or separate height plane restrictions or anything else merely because it was bisected. Next one, please, Shauna. And this one's right across the street. This is the condominium directly across from our property, which is up here. Same thing. City line totally bisects the tract, totally bisects buildings. No setbacks measured from the city line. Setbacks are measured from the property line, which is exactly what we are contending should be done here. At that point, having had those conversations, the property was placed under contract to Brand Properties. On October 18th of 2012, Brand met with David Cullison to have the exact same discussion. None of these folks, the broker, the property owners, or the developer, are unfamiliar with how zoning works, and they wanted to make real sure before they spent a penny on this project that they could do what they wanted to do, because otherwise there was no point in going forward. And once again, they actually received those assurances. On October 19th, David Cullison advises Gary Cornell in the county, and this is a double one, Shauna, that the application is coming in, that they're trying to get it in before Brookhaven is incorporated, and Cornell doesn't say, you can't do that because the city is incorporating, or if you're in mid-permit process because the city is actually incorporating, you'll have to go there. All he says is, tell them to bring in a site plan with very limited materials on it. Between October 19th and November 1st, people from Brand Properties met with representatives of various other departments in the county. All of the feedback was positive: fire, transportation, watershed, and the arborist. Every one of them said the project could be done. No one had a bit of concern about it. So ultimately, Brand Properties completed this application for an overlay certification of compliance. This is separate and apart, folks, from going after a land disturbance permit. It is not the same thing. All they were asking in this document is for the right to be told that, yes, if you develop this project, it complies with the overlay. The intent was to get that first, and then to go after the approval of the full land disturbance permit, which is a completely different and more complicated set of documents. And with this application, they filed what Shauna is showing you now, and this is all in the voluminous exhibits I'm sure you were perfectly delighted to receive from me yesterday, and I'm sure you delved into them at great length and enjoyed them all last evening before you went to bed. which is why I'm reviewing them a little bit more now. But that is what we filed. No more, no less. We were not told when we filed it that it would not be processed, that it would not be accepted, and in fact, and slide 19, Shauna. The next email we have here is from David Cullison advising the commissioners that this application had been filed. Not an incomplete application has been filed, an application for overlay certification has been filed. So, during the process in which we're going through this, David Cullison decided, rightly or wrongly, that he wanted more detailed plans. So we gave them to him. We went ahead, could you hand me this stack, Shauna, down here? And we produced $66,000 worth of land disturbance permit plans to give David Cullison the detail that he wanted. And what do we get back in response from that? He doesn't have sufficient detail to begin the overlay review. That's really not what happened at all, and that's not what was said during the process of reviewing either the overlay or the application for an LDP. Could you please show me 24, let me see here. 22A and B, no, I'm sorry. 21A and B, please. You'll notice conspicuously that on December 10th, which is an important event as I'll describe to you, there is no comment on this set of compliance reports out of the county that says that density is limited in any way. Somebody obviously was told to revise that, which was revised on December 12th, and that's the first time that appeared in written documents. What is my return? Where are my stamp plans, Shauna, do you know? No, they're up there somewhere. We cannot find them. Again, I'm not technically proficient, but I provided to you all of the development comments with regard to the land disturbance permit. Every single one of them said, fix this and return. Not, we reject this, fix this and return. Not, pay a different filing fee and return, fix this and return. And that's true for every single comment that we got and every single thing we were told after we filed our land disturbance permit on November 30th and went through the first stage of review with the county on December 10th. But as I just showed you on December 12th, he came out not only with an objection to the height plane and the buffer issue, as we have just been discussing, but also insisted at that point that we also were limited to 18 units per acre. And that's what we appealed. We did not say we were entitled to the certificate at that point. We had more work to do. We acknowledged that. But we were in process, and we were entitled to continue that process. And that's what we protest, that we were cut off midway. We're entitled to file an appeal. That happens all the time. You go in and you're in the review process, they tell you something, you don't like it, you appeal it, you resolve it, you come back. But they were not entitled to kick us out of the process merely by virtue of the fact that we filed that appeal. And when we filed it with DeKalb County, we paid a filing fee there. We were accepted, we were processed, we were placed on an agenda, and we were advertised fully. So now we have paid $61,000 on plans. We have paid $3,000 some odd to file those plans with the county, which were processed and accepted, and that check was cashed. And we have paid a $300 appeal. And now we're being told that suddenly we have to come to Brookhaven because our plans have been failed. How did that happen? When this process started, I did two things. I'm somewhat smart, not completely. So my first instinct was to try and set up a meeting with community members in the immediate area of this project to see if there was a way, we knew this was going to be controversial, to see if there was a way that we could reach some compromises. And we went into that meeting and said to them, based on everything we've been told, look, we can do this, folks. We believe we can do this. So we want to work with you. And in fact, we employed Fritz Reibert as part of the development team who lives in the community to work with the neighbors in the hope that that would appease them. That was the first thing we did. The second thing we did, which I feel really foolish about now, is that I decided to set up Mike Elliott of the VPCA with the developer. Mike asked for the plans. He assured me that he would help me work through this with the community, that he understood that this could be going on the site, and that he would, in fact, work with us to help facilitate that. So I sent him everything. Unbeknownst to me, he was turning around and sending them to Jeff Rader. And then that sort of diverged, I think, from what I thought he meant when he said he was going to help me. But He also then began organizing, or BPCA began organizing, a campaign against this application. We filed it on November 8th. November 9th and 10th, there were 13 letters that went into the county. And as soon as they went in, the development director started questioning why we've been told that we can do the things that we can do. So, additionally, on the same date, Mr. Elliott sent an email to one of the commissioners, Jeff Rader, not to all of them, and as well as a copy to Jack Hundred, another BPCA principal. Shauna, could I see number 29, please? This one's bothersome. Because here's what he says. He reported that he understands that Brand's due diligence period under its purchase contract was to expire in mid-December. He also advised that our joint strategy will be to seek to determine that the plans submitted do not fully comply with some terms of the overlay and seek to have the plan review fail, have the plans be rejected. Secondly, we will seek to delay approvals until the due diligence period passes and hope that the developers decide not to pursue the property. Putting aside interference with contract issues here, it is very clear that the plan was then derived that this set of plans was going to be failed and kicked out of the system, contrary to the way every single other applicant in DeKalb County, ever has been treated. On November 20th, when all of this was going on, Shauna, if you could please pull me up 30. Yeah, you've got it. That's it. Gary Cornell reported to Luz Barrero, who is new in the planning department, and his superior, that there were issues with the application. And he stated, and I'm quoting from that exhibit, county policy regarding density and height is different in the comprehensive plan, the LCI plan, the overlay district, and the zoning district. He admits that there's utter confusion. Nonetheless, he ended by stating that he had directed his staff to interpret the different policies in the strictest way possible. So he has decided that it will be applied strictly, regardless of what these various documents are saying. And that absence of clarity of what these documents are saying in and of themselves creates a real legal problem. Because Georgia law is very clear that zoning is in derogation of the common law, which is a fancy way of saying people are not, it's not favored to restrict people in their use of properties. And therefore, if a zoning ordinance is unclear, the unclarity gets resolved in favor of the property owner. By admission of DeKalb County, what applied here was unclear. The benefit should have gone to the property owner, not the strictest, most interpretation. But then Brookhaven somehow ends up with the appeal, too. It's filed December 13th. Brookhaven isn't even in existence. All these plans are filed before Brookhaven is in existence. And I'm not understanding that at all, because you didn't take over planning and zoning from DeKalb County until January 17th. You announced publicly at a number of meetings that I attended and others attended in the community that you would be processing new applications and DeKalb County would be processing ones that were filed with it. And the moratorium that was imposed on DeKalb County was imposed on only new applications. Slide 31, please, Shauna. Okay, Shauna, we'll probably skip the moratorium slide here. There you go. Fourth paragraph of the moratorium provides that it is against new land disturbance permits, new land development permits, etc., not ones that were pending. However, what then happened is that Brookhaven began almost immediately to get involved with the, quote, club drive situation. And I provided you with all these emails, and I'm not going to re-show them to you because you can look at them in your book. But what we have is that on December 27th, 2012, Gary Cornell sent Ms. Garrett an email, the county's files on the two applications. He expressly advised that the appeal had been scheduled for hearing before the DeKalb Board of Zoning Appeals. He then asked whether the city attorney had any opinion as to whether the county had jurisdiction. Now, your charter expressly said that DeKalb County retained jurisdiction until you advised and gave 30 notice to take it over. That's not unclear in the slightest. He then continued to explain that the case is complicated because the county accepted the land disturbance application and fee, and because, and I am quoting, density is hard to establish. He expressly characterized the case as messy, again establishing uncertainty because density is hard to establish. And as I've just discussed with you, that is not an open question under Georgia law. That gets construed in favor of the property owners. However, apparently thereafter, without explanation, someone determined that it was appropriate for Brookhaven to assume jurisdiction. By January 10th, there are emails indicating that the city manager, councilperson Iyer, councilperson Madison, and the mayor had long meetings concerning this project. By January 22nd, there's an email chain where Ms. Garrett says she will attend a meeting the following day at Ms. Dunleavy's office with Mike Elliott, Jack Hondard, Councilman Madison, and others to discuss a strategy for presenting arguments against the appeal at the then scheduled DeKalb County hearing. The same time, the county then released the case to Brookhaven. The paper trail strongly suggests that this was an engineered effort by this group of people on behalf of Brookhaven to get it away from DeKalb, because they knew if it was heard in DeKalb, there was a real strong possibility that the DeKalb County Board of Zoning Appeals would rule differently than a Board of Zoning Appeals that is composed only of people from Brookhaven. And these activities of this group...
One to watch.
Please, no outbursts from the crowd. The applicant needs to have their time to speak. Thank you.
And this activity was furtive enough that, again in an email, Councilperson Iyer urged the city manager, the mayor, and the Councilman Madison to be more cautious about communication with me. Please understand, he said, information should be kept confidential as it could affect our position going forward. We have already tipped our hand once when Linda Dunleavy called Kathy to inform her the case was leaving DeKalb before Marie did. It was orchestrated. 1 week later, in an email also sent to the mayor, Councilman Madison, and Councilman Iyer, Jack Hondard thanked Ms. Garrett for the city's support of the opponent's position. And then we got advised of the transfer, which we protested then and still do. This transfer impacts upon our substantive due process rights. You just adopted your rules of procedure. I didn't know what you were going to do tonight. I'm not sure 30 minutes, quite frankly, is sufficient. You don't have subpoena power. DeKalb does. I can force people to come testify in front of DeKalb County. I can't do that here. And this has an appearance of impropriety such that you must be as fair as DeKalb is to make sure that my clients' rights are protected. I get that this is a new city, but it's still a city subject to rules, constitutional and statutory. It is not a civic association that is to be run like one. A government must respect those rules, and you cannot violate equal protection rights and plug out my clients from everything else that was going on in DeKalb County and treat them differently, whether you like this project or not. And I get that people don't like it. That's not a reason to vote against it legally, period. It is that simple. And after engaging in this behavior, the city and the county have completely departed from the rules and regulations applied to every other single applicant. And then the city compounds it because we've also got an application in here from Wood Partners. I'm sure you know about it. It's on Dresden Drive. It is, I think, it's 3.15 acres with 250 apartments. The LDP was in process in DeKalb County when Brookhaven came into being. It wasn't transferred over to Brookhaven. It issued in DeKalb County on January 18th. And the property on which it is located is zoned RM75 and R75. You got the land disturbance permit, and I thought maybe, given the way this matter was being treated, you might question it, but you didn't. Your department processed it and already issued building permits. So while we're going through this process, that's happening. There's another one that is, oh, and by the way, when Wood was going through the process, their plans were failed on multiple occasions. They went in to meet with the county. County said the plans aren't good enough. You're going to have to come back with revisions. They did. They weren't thrown out of the system. They weren't rejected. They weren't told in any way that because their plans were inadequate, that they could not be processed. Hines is another example of how people have been treated differently in terms of the very issues that are involved here. Hines is out of the ground on Dresden. I handled that. The underlying zoning is C1 and O&I. The underlying O&I zoning prohibits any kind of apartment unit over 3 stories if the property adjoins single family, and this one does. Your overlay says it can be up to 4 stories. And under the same kind of reasoning that was applied here about the 18 units per acre being the underlying zoning, that should have been limited to 3 stories. It wasn't. And it wasn't because that is DeKalb's policy. This isn't a matter of inconsistent provisions. This is how the ordinance was interpreted and applied to a myriad of individuals. And you cannot depart from that policy and give a brand new interpretation, which by definition is arbitrary. I gave to you in the packet applications of everyone who has filed for a certificate of overlay compliance over the past, I don't know how many years. None of them were more complete than ours. All of them were approved. I gave you the wood development plan review comments. Multiple occasions of failure. None of them were refused. McDonald's came in and asked for a permit to do a renovation of McDonald's. They actually were failed on the first set of plans under the overlay. They were not kicked out of the system and prevented from going forward. This is an effort to stop this project in a very unique and a very arbitrary manner. There's also another one that went through on land disturbance permit, which I forgot to mention, and it wasn't pulled, and that was Worthing Southeast. They actually applied in December for their development on Johnson Ferry East, not an overlay project, but the LDP application was pending. Their plans were redlined, accepted, not sent over to Brookhaven, and on January 13th, they were issued an LDP. I think the thing that bothers me the most, though, in terms of these underlying issues, is what else happened with the wood application during this process. Shauna, can you pull up 63A and B, please? At the first meeting, while she's doing that I met with the neighbors at, somewhat ironically, they had employed Carl Westmoreland. I say ironically because he, like me, is normally a development lawyer. But he was there and he told them the same thing I did. It looks like they can do this. We need to work through it. And he was present, so he knew exactly what we were trying to do. Carl also represented Wood Partners. So when the comments started coming in that said, because your underlying property is RM75, you can't do this, you're limited to that density, understandably, with his client going through the process at the same time, he was a tad bit worried about that. And this exhibit, and you have to start on the right side of the page and go up the other because of the email starting at the bottom of the page. Carl expressly says, I assume that by this letter you are confirming the density for the project is determined by the overlay regulations and not by the underlying zoning classification, as I understand is the case on Peachtree development proposed by Brand. Gary Cornell says, Carl, there is no reference to density in the Peachtree Brookhaven overlay. There are height restrictions. Westmoreland says, which means in the Wood case that the density specified in the underlying zoning, O&I, residential multifamily, single-family districts do not apply. Cornell, we have reviewed the Wood application based on the building height and bulk and architectural form, which is exactly what we were told would be the review process for us. We have interpreted the meaning of the overlay to be that these factors can be considered to modify the provisions of the underlying zoning district. 2 days later, that overlay certification to place 230 apartment units on 3.15 acres was approved. That's December 6th, 4 days before ours was denied for directly contradictory reasons. I supported Brookhaven, yes. I did so because, for that matter, I supported many of the candidates who I'm sure now are really mad at me. I did so because I wanted out from under DeKalb County for the benefit of Brookhaven too. DeKalb County has not been a fun place to work for anybody, regardless of who you represented or what your efforts were. And I wanted out, and I thought that was over. I thought by creating Brookhaven that nonsense was gone. But if you allow behind the scenes machinations of a very vocal minority to control, then you're starting off no better than DeKalb, because that's part of the reason that Brookhaven was created. I know that what I'm asking you to do is not popular. I know that some of you are active members of the civic associations that are opposing this. I know that you also, however, a lot of these people live in the city of Atlanta and not just on the DeKalb side of the line. And I also know that notwithstanding 34 years of practice of law, I still believe in it. I believe in the oath. I believe that when you swear to tell the truth, you do. I believe that when you all swore to take this office and to discharge your responsibilities, that you meant it. And when you swear to uphold the law, you must uphold the law, regardless of whether you like it or not, regardless of whether your neighbors like it or not. It is what you would swore to do. So I'm asking for the following. Number one, send this mess back where it belongs. This is a hot potato that belongs to DeKalb County. The only time I've seen somebody mess with a project like this was the recent mess in Atlanta over the discount stores you might have read about over the summer. I think it was Family Dollar. Councilman interfered, stopped the permitting process. City of Atlanta is now paying $1.8 million to get out from under that mess by buying the property. I don't think that's in the City of Brookhaven budget. Let DeKalb County do that for you if you would like them to. If not, affirm this appeal. If nothing is arbitrary conduct, what I have just described to you is you cannot single out one and treat them differently than the whole. And I'm going to make a third recommendation, which is something that I've given a lot of thought to. I want you to consider a deferral. I dumped a lot of information on you. I'm suspecting you didn't have time to review it. I know you're new to this. I don't mean that disrespectfully, but I know this is not something you've been doing and are probably very excited about doing at this point. I'm sure the city attorney, who I've worked with a lot, may be unaware of some of what I shared and might want to weigh in on it. And I think you owe it to all concerned to take as much time as you need to make a considered and informed decision here. I suspect the city might want to or ought to have further discussions with DeKalb County. I am willing to enter into discussions with people who oppose this project, facilitated by the county, to see if a compromise can be reached. So I am asking you, you have 60 days of right to do that. If you can't see your way clear on the first two options, do it. There's no harm. And if the opponents to the project don't want you to do it and want you to vote it down instead, what are they afraid of you finding out? Just take the time to make sure you understand all the facts here. There are a lot of them, and they look very, very bad. Thank you. I'll save my 58 seconds for rebuttal.
Thank you very much.
Mr. Chairman, when would it be appropriate to ask our questions? After the second presentation?
Yes, that's correct. Okay. Ms. Dunleavy.
I have some additional documents. I'm not sure exactly how you all would like to handle this. Unfortunately, like yourself, I received Ms. Zickert's binders full of documents yesterday and wanted to submit some additional documents for the record to the board, partially in response to that. So I'll hand those around right now.
Is that for me?
Yep. While that is being handed around, my name is Linda Dunleavy. I represent the Brookhaven Peachtree Community Alliance. I also represent Historical Brookhaven Neighborhood Association, and I represent Walt and Nell Mailing, the property owners at 1227 Bel Air Drive, which is the property immediately adjacent to the subject development, which is the subject of this appeal. There are a large number of people here who also oppose this appeal, as evidenced by the I Love Brookhaven stickers. I was going to ask them to stand, but the majority of them are already standing, so presumably you can figure out who they are. The appeal, the opposition to the appeal that is being lodged is that simply the applicant has not complied with the specific requirements for overlay approval. This, coupled with the significant impact that this development would have on the immediate neighborhood, on the city of Brookhaven as a whole, on the process whereby overlay compliance is determined, forces our opposition to this appeal. What has been handed around to you, just that I might note for the record, are additional documents. We have submitted a large package, which I believe Mr. Coons has already provided to the zoning board. But what you have in front of you is a certified copy of the RM 75 zoning regulations that were in effect at the time this application for overlay compliance and the land disturbance permit application were filed with the county. You also have a zoning agreement between a prior developer for 3804 Peachtree, which is one of the parcels involved in the subject appeal, wherein the developer, with the owner's consent, agreed to develop the property for 8 townhome units. The current proposal provides for 178 apartment units on 2 acres at an effective density of approximately 87 units per acre. You also have in front of you written statements of Richard Asbill. He is a resident of the Townhome Association across the street from the subject property. You also have a written statement from Mike Elliott, who is an officer of both the BPCA and the HBNA. Mr. Elliott's name has come up several times during the course of Ms. Zickert's presentation this evening, and also in the written submission that she has filed with you, wherein she alleges some sort of orchestration to avoid DeKalb County processing this application, some behind-the-scenes machinations, and Mr. Elliott felt that he needed to submit his own statement in defense of those accusations being lodged at him. Both of these statements dispute some of the facts or the alleged facts that Ms. Zickert throws out in her written submission to you and her oral presentation this evening. And I think if you review those statements, you will see quite a different story comes forward than the characterizations of Ms. Zickert this evening. Additionally, you have some additional letters in opposition to this appeal as part of the packet submitted to you tonight. So, why are we here tonight? I submit to you we are here tonight not because there were some orchestrations or there were some behind-the-scene dealings. We are here because the developer of this property proposes to put 87 units per acre, more than 20 units per acre than any other development that has ever been allowed in the Brookhaven Peachtree overlay. We are here tonight because the owners appealed 3 elements of a decision that was made by DeKalb County. There are only 3 discrete challenges. Ms. Zickert has not challenged on behalf of her client that there are approximately 30+ deficiencies in the overlay compliance, in the overlay certificate application that was filed by her client. So let's focus on those 3 issues. Let's set aside all of the somewhat interesting, dramatic background information that has been put forward by Ms. Zickert and take a look at what the 3 issues are before you tonight. The first issue is whether the proposal submitted by the developer exceeded the allowed density for the subject property. That's number 1, and that's the issue raised in Ms. Zickert's appeal. Number 2 is whether a transitional buffer and height plane between the overlay boundary and the City of Atlanta property. I'm not as fancy as Ms. Zickert. I'm even less technical than Ms. Zickert, so I don't have the PowerPoint to show you. But if you recall, there are 2 parcels identified as comprising the subject property. One side of the subject property is within the City of Atlanta. So the second question is whether a transitional buffer and height plane is required between the City of Atlanta portion of the property and the portion of the property that is in DeKalb. The third issue raised by Ms. Zickert, quite honestly, I still find myself scratching my head and I'm not really sure where she's going with this. But as I understand it, her client is asking whether the county went too far in asking for details on the overlay compliance request, or whether the county somehow was incorrect in failing to process the overlay application and the land disturbance permit application once the City of Brookhaven came into being. Unfortunately, none of these issues were fleshed out in the original appeal. The first time that I saw this issue being raised by Ms. Zickert was yesterday in her materials, and so I'm still trying to grapple with exactly what it is that Ms. Zickert is saying on that third issue. So quite frankly, I'm just going to address the 2 issues that I understand are the crux of this appeal: the density issue and the transitional buffer and height plane issues. Now, you can choose to get down in the weeds with Ms. Zickert with the conspiracy theories on how this matter came before you. You can choose to follow her down the garden path concerning the motivations of these meddling neighborhood folks. You can get hung up on the alleged use of the word fail. You can get hung up on all of the behind-the-scenes machinations. However, I guarantee that if you go down that path with Ms. Zickert, you're going to get confused as to exactly what are the issues before you. So I ask that you please focus on just those 3 issues that have been raised in the appeal. When you focus on these 3 legal issues, my clients and I are confident that you will find that the DeKalb County staff made the right determination in regards to this property. Just as an aside, I do want to mention that the jurisdictional issue that has come up before you, Ms. Zickert is asserting in her written materials that this board does not have jurisdiction over the appeal, that it should be sent back to DeKalb County. My clients do not take a position on that. We are here to discuss those substantive issues. There has been no orchestration of this transfer. If you take a look at the affidavit that's been submitted by Mr. Elliott, he puts pay to that. I personally called Ms. Zickert as soon as I heard from DeKalb County that there was some idea that this matter would be transferred to the city of Brookhaven. I did not meet with Ms. Marie Garrett or any representatives of the city of Brookhaven before this matter was transferred to the city of Brookhaven. This meeting in my office never took place, and in fact I advised my clients, you don't want to have that meeting. That is inappropriate. We are not going to meet with members of the city of Brookhaven because at that point in time the appeal was pending before DeKalb County. So let's focus on the first issue, and that is density. It's undisputed that there are now 16 apartment units on the subject property. That's the sum total. And that appears in Exhibit 2 of Ms. Zickert's material, which is an affidavit of the real estate broker, Robert Jordan, who marketed this property to the current developers. It's undisputed that the subject property is zoned RM75, which is a multifamily zoning classification which allows only up to 18 units per acre. There are approximately 2 acres on the subject property. So if the underlying zoning governs, then the maximum number of units that could be put on this property are approximately 36 units. The developer is proposing 178 units. It is also undisputed that the land use designation on this particular piece of property in the comprehensive land use map adopted by DeKalb County is suburban residential. That classification only allows up to 8 units per acre. Finally, it is undisputed, and in fact in the materials submitted by Ms. Zickert herself, the Brookhaven Peachtree LCI map designates the subject property for medium density. If you take a look at the binders that you received in Exhibit 2, Ms. Zickert kindly provides a copy of the overlay map that was adopted by the LCI group, and it shows medium density for the subject property. There is no definition in the overlay of medium density, but there is a definition in the zoning ordinance. And that definition defines medium to high density to be certain uses not exceeding 18 dwelling units per acre. So certainly the base zoning designation of RM75, which allows up to 18 units per acre, is also consistent with the LCI designation of medium density, which would allow up to 18 units per acre. What is disputed in the appeal filed on behalf of Ms. Zickert's clients is whether or not the overlay regulations somehow trump the underlying zoning designation. Does the overlay somehow allow additional density? The issue of what is allowed in regards to density is purely one of interpretation of the codes of DeKalb County. And you, this body, are the body that gets to, unfortunately for you, decide what those ordinances mean. You get to decide, not Mr. Cornell, who characterized the regulations of the overlay as being messy, not Mr. Cullison, who characterized density as somewhat of an open issue. You, as the reviewing body, get to look at the ordinances and decide, in your own mind, based upon your own interpretation of the clear language of the DeKalb County zoning ordinances, what density is allowed on this property. Ms. Zickert wants you to go behind what I believe are the plain and unambiguous terms of the zoning ordinance and look at such things as other projects that were approved in this overlay district. Look at other projects that existed even before the overlay came in. She wants you to go back behind that language. You don't need to go there. And in fact, as a matter of law, you shouldn't go there. If you find that the language of the zoning ordinance is clear as to density, then you have no business going behind and looking at other projects, looking at emails from various people in DeKalb County. You look at the language of the zoning ordinance. And only if you find it ambiguous do you go behind it. So let's take a look at the language. I don't know what materials you have with you tonight, so please bear with me. I'm going to read the language of the ordinance, but perhaps you will have time to take a look at the ordinance yourself as I do so. If you take a look at page 14 of our statement, which was filed in opposition to this appeal, I quote verbatim the language of what I believe are the controlling provisions of the DeKalb County ordinance. The first provision is found at 27-656 of the code. And this is a general provision in the DeKalb County ordinance concerning overlay districts. And once again, this is on page 14 of our opposition statement.
What's the code again?
The code section is 27-656. That is the code section before all of the overlay districts that were adopted by DeKalb, of which Brookhaven Peachtree overlay is a part. That section says overlay districts are supplemental to the zoning district classifications established. Supplemental to the zoning district classifications. It goes on to say that all development and building permits for lots located within an overlay district shall meet all of the requirements of the base zoning district in which they are located, and in addition shall meet all the requirements of the overlay district. So this section, if you read this section, I think it is very clear that this section is saying as a general rule that overlay districts have to comply with the base zoning classification regulations, in this instance RM 75, which provides for 18 units per acre maximum, and in addition has to meet the overlay district requirements. The next sentence is the key sentence and probably the crux of my dispute and Ms. Zickert's dispute with respect to density. That sentence says that where there are conflicts between overlay district regulations and other regulations contained in the code, the overlay regulations shall govern. Ms. Zickert, on behalf of her clients, takes the position that the Brookhaven Peachtree overlay overrides the density restrictions in the base zoning district here, the RM 75 zoning district. However, we submit that Ms. Zickert's interpretation is incorrect. Why? Because there is nothing in the Brookhaven Peachtree overlay regulations that specifically addresses density. It doesn't address density in terms of units per acre. It doesn't address density in any way, shape, or form. I did a word search, and the only time you find the word density in the Brookhaven Peachtree overlay regulations is where it expresses a preference for higher density closer to the MARTA station, and where it says that when you file for an overlay compliance certificate, you have to identify the density requested. I submit to you that there is no conflict as a result of that between the overlay regulations and the RM 75 regulations. The RM 75 regulations are very clear. You cannot put more than 18 units per acre on an RM 75 zoned piece of property. It doesn't conflict with the other things that are provided in the Brookhaven Peachtree overlay. The overlay deals with heights, it deals with setbacks, it deals with architectural features, it deals with bike racks, it deals with sidewalks, it deals with transitional planes and transitional buffers, but it doesn't deal with density units per acre. So there is no conflict. So we submit, based upon that clear language, that the density provisions of the RM75 base zoning district apply, 18 units per acre, not the 87 units per acre that are being sought by Ms. Zickert's clients. Now, Ms. Zickert attempts to get you to go behind this language, as I said, by providing you with document upon document upon document in these big binders of all other kinds of projects that have apparently gone through DeKalb County overlay review. Only 2 of these projects identified by Ms. Zickert are multifamily projects, like the project before you tonight. Only 2 deal with the new construction of multifamily projects. Ms. Zickert and her clients point specifically to Alta Brookhaven and Ashford at Brookhaven. These are 2 projects that went through overlay compliance review. Both were submitted in 2012. The overlay has been in existence since May of 2007. So the overlay was 5 years on before these applications even came before DeKalb County. The Ashford at Brookhaven was the first one. It was zoned office institutional and commercial C1 classification. And it allowed up to 64 units per acre. The project was given overlay approval by DeKalb County in mid-2012. I submit that the explanation for that is that because the underlying zoning was C1 and OI, did not have density limitations like you find in the RM75 zoning classification of 18 units per acre. Merely regulated setbacks, lot coverage, floor area in some instances, height in others. The second project to come through, which was a multifamily new construction project, was the Alta at Brookhaven. It was approved for overlay compliance by DeKalb County on July 27, 2012. Interestingly, the project that is before you tonight was presented to DeKalb County only 11 days after the Alta project was approved. The Alta project was engineered by the same folks who were squiring through the subject development. The approval of these 2 projects that were submitted fully 5 and 8 months before the subject project should not control the outcome in this case. It should not control the outcome in this case, first of all, because the language of the ordinance is clear and you shouldn't even go behind it and look at these other projects. Secondly, it shouldn't control because on the Ashford parcel, the zoning was C1 and office institutional without any unit per acre restrictions. Second, with respect to the Alta project, we maintain that the county made a mistake. This mistake was clearly recognized when Mr. Cullison and Gary Cornell advised the developer of this project that a different interpretation of density and transitional requirements than had been previously discussed with the developer would be applied. I invite you to take a look at Exhibit 36 in Ms. Zickert's materials. That exhibit is an email from David Cullison to a representative for the developer, telling the developer very early on that we are going to apply an interpretation with respect to density that is somewhat different from those informal conversations I had with you before you submitted your formal application. The approval of the Alta project does not prove some sort of conspiracy or some irregular change of interpretation, but as stated by Mr. Cullison clearly in this email, they had had reason to interpret the ordinance differently. Why? Why? One thing that Ms. Zickert does not tell you is nobody objected, nobody raised the issue of density on any of these projects. And so the county just did not drill down and look closely at its own ordinances. But when it did, it realized that the base zoning district regulations applied, that the base zoning district limitations on density controlled. In these 2 projects, only 2 projects of multifamily construction prior to this, no challenge was ever made to density. However, the challenge to density should come as no surprise to the appellants in this case. Their own real estate broker, in the marketing material that has been submitted as Exhibit 24, an attachment A on page 2 of his affidavit, indicates in the marketing materials that the DeKalb County portion of this property is zoned RM75, quote, which provides for the development of multifamily at a density of 18 units per acre. The density restriction should come as no surprise to the appellants in this case. They agreed to sell the 3804 side of the project back in 2008 to a developer who was going to develop it for townhomes at 8 units per acre. It should be no surprise to the appellants that this project is limited to 18 units per acre. Probably what was a surprise, I think, was that the Alta project got approved. They jumped quickly on the bandwagon by submitting a similarly dense project using the same engineers as the Alta project, to do so in hopes on capitalizing on the surprising density permitted in the Alta project. Don't jump on the same bandwagon. The language is clear. Density is limited by the base zoning district to 18 units per acre. The same is absolutely true with respect to the second substantive issue raised by Ms. Zickert in her appeal, and that is the transitional height plane and transitional buffer issue. She can't make the same bandwagon argument with respect to the transitional requirements that are clear in the Brookhaven overlay regulations. In fact, in her presentation in chief tonight, the only thing that was pointed out by Ms. Zickert that I recall in regards to these transitional requirements were 2 projects straddling jurisdictional lines, 2 projects which way predated the Brookhaven overlay regulations that did not have to go through overlay compliance review. I am unaware of any project that has had to go through compliance review since the Brookhaven Peachtree overlay regulations have been put in place. The appeal argues that these requirements should not apply to the subject property because there is this one parcel that is partially in DeKalb and partially in the city of Atlanta, and there's no property line down the middle. In making this argument, they want you to ignore the jurisdictional boundary line between DeKalb County, or what is now the city of Brookhaven, and the city of Atlanta. That line, that boundary line, is the overlay district boundary line, and it is divided with the city of Atlanta having a single-family residential classification on one side, R3, and the Brookhaven overlay on the other side. The language of the ordinance, once again, and the pertinent language I maintain is found at 27-728.15.6. That language states that where a lot on the external boundary of the Peachtree overlay district, not the boundary of a property, not the boundary of a parcel, but where a lot is on the external boundary of the Brookhaven Peachtree overlay district, and I think if you look at the map, it's pretty clear that this part of the subject property is on that external boundary, adjoins the boundary of any property outside the district that is zoned for an R zoning classification, then transitional height plane and buffer requirements apply. There is no dispute that the city has an R zoning classification. There's no dispute that the overlay divides the parcel. Clearly, if the drafters of the ordinance had intended that transitional buffers only be provided where parcel lines had been dropped by the owners of the property or whoever platted the property back in 1955, they would have said so. They didn't say that. They keyed the requirement for transitional buffers and transitional height planes to the external boundary of the overlay district, where it adjoined a single-family zoning classification. And that makes sense. I mean, given that the overlay provides generally for lesser setbacks, provides for greater heights than you would find in most single-family residential areas, it makes sense that you would want to have a perimeter buffer around the entire overlay where it may adjoin single-family residential properties, regardless of whether they're in the city of Atlanta or they're in DeKalb. If they adjoin single-family residential properties, those transitional buffers apply. And so we believe that you should uphold the decision of the county as to the transitional issues also. We do not object to a deferral. Like the board, I received this massive package yesterday midday and certainly have not had time to observe all of its nuances. And we don't object to having any discussion with Ms. Zickert and her clients in regards to some sort of compromise. We have asked for that previously and have not, quite frankly, been able to set up such discussions, and so we would welcome that. I do have a couple other speakers who would like to present in the time that we have left, and so I'd ask Mr. Scherer to stand up.
My name is Will Scherer. I am a resident on Bel Air. I'm a next door neighbor to Fritz Reibert. I bought my piece of property from Mike Elliott, and I grew up with Bran Morgan. So for some unknown reason, I have all these intersecting pieces on this, this matter. The other thing that I think is interesting is the question sort of why DeKalb County might have changed their perspective on the analysis might actually stem back to a letter that I wrote in November 11th. And there's this question that sort of arose when there was a meeting next door at Fritz's house that I did not go to, where Mrs. Zickert and her clients met with some of our neighbors. And in that meeting, it was presented, and Ms. Zickert said that this development's going to go forward, and it's proved you really can't do anything about it. That's how it was presented to me. So as a neighbor who was confused by the fact that you could have a 176 apartment complex right up on the end of the street, I took it upon myself to do my own review. And when I read the code, which I know each of you will do, it was really actually very clear to me. It was simple. I mean, it's the nice thing about me looking at it is I don't do zoning every day. I read it for what it said, and it makes very clear sense to me. The overlay is straightforward, and there is no conflict between the overlay and the underlying zoning. When I saw that the DeKalb Code says that the underlying zoning regulations govern, just like Linda read, I then went straight to the overlay and said, well, where does it say density anywhere in here? And it doesn't, just like Linda said. And it says that you can have 6 stories instead of 4 stories, which is in the RM 75. So my conclusion was to my neighbors who we were talking about this, look, we may not like the fact that they can do 6 stories instead of 4 stories, but it looks to me like they can do it, but they're subject to 18 units an acre. So if they want to build a 6-story, 18 unit an acre place, we might have, not much ground to stand on. But the reality is that they were asked for 87 units an acre, so it didn't make any sense to me. So I wrote the letter into the commissioners at the time. And as you look at it, I actually don't think this is an interpretation issue, quite frankly. Okay. May I ask if we have a little more time?
I think we voted in the beginning of the meeting to extend the period for both sides to a total of 30 minutes, which is 3 times the amount of time allotted in our procedures. So I think now would be the proper time to close the public.
I have 58 seconds left.
Okay. All right.
Thank you for your time.
58 seconds.
Thank you. Linda's right. If going forward the city of Brookhaven elects to interpret this ordinance this way, that is your prerogative. But the letter that transferred this case to the city of Brookhaven said, we will consider this under the laws in effect in DeKalb County. In DeKalb County, the determination was made that it was unclear. In DeKalb County, as a consequence, they did an interpretation that allowed this kind of thing as to Hines, and it wasn't the density, it was the height that's often Hines. And in Wood Partners, there have only been 8 overlay applications in the entire history of the overlay, which might say something about the overlay itself. You've got them all in my materials. No one else was subjected to these rules. No one else was required to be kicked out of the process, and we shouldn't be either. You want to go forward and apply it that way, please do, but be fair as to what it should be applied to my client. I have 3 seconds.
You saving that?
Yeah.
Okay, thank you very much. This will conclude the public comment section of the meeting. So I will open it up to the board for any discussion or questions or comments that you want to involve.
I have some questions.
All right, Mr. Beard. Go ahead.
Thank you. First, just a couple for Ms. Dunleavy. In your presentation, you cited you mentioned an overlay map when you're talking about the comprehensive land use plan. You mentioned an overlay map that referred to the term medium density. Can you be a little more specific on where that is? Is that in a code section?
Yes, I found that in reviewing Ms. Zickert's exhibits. I don't know, can I ask Shauna to show me Exhibit 2 on the overhead? I believe that's the overlay map that I was referring to.
So it's in the overlay map, is what you're
It's
saying.
in the LCI map, the Brookhaven Peachtree LCI, which formed the basis for the Brookhaven Peachtree overlay regulations that were ultimately codified in the ordinance.
Thank you, that answers
And
that
if you
question.
take a look, this is the map that I'm referring to. On the far left-hand side there, you will see the subject property, kind of a muddy brown rectangle. And then if you compare it with the index on the right-hand side, that index references medium density. That's where that reference was meant to be made to.
Okay. My next question is, when you were talking about the Alta Brookhaven project, you mentioned an 11-day, something was approved 11 days after something else. Could you clarify that?
I just find it very interesting that there have been, as Ms. Zickert states, there have been very few new construction applications in the Brookhaven overlay since its inception 5.5 years ago. The Alta Brookhaven application was for a multifamily residential use similar to what is being proposed here. That particular project was approved for overlay compliance sometime in July of 2012. 11 days later, the affidavit of Mr. Jordan, who is the real estate broker for this particular property, he states that he met with DeKalb County to discuss overlay compliance on their sort of conceptual plan that they had put together. That was the 11 days.
Who's Mr. Jordan?
Mr. Jordan is the real estate broker, as I understand it, for the owners of the subject property, and his affidavit appears, I believe, in Ms. Zickert's materials as Exhibit 24.
Okay.
He has an affidavit, and then attached to the affidavit are his marketing materials. Yeah, Exhibit 24.
Thank you. I'll ask questions for Ms. Zickert now.
Here.
Ms. Zickert,
Just stand right here.
who was your original client in this matter?
Brand Properties.
When were you first engaged by Brand Properties?
I think about September 15th.
Are you aware of when the vote took place to make Brookhaven a city?
Of course.
What's that date?
Oh, you mean the actual date, or
Yeah.
was I aware of when it occurred?
Yeah.
I believe it was the end of July.
Right, July 31. So you were originally engaged by Brand Properties, but now your documents say you're engaged by the Tomlinsons. Can you, being the owners, can you explain how the transition took place from your engagement by Brand Properties to your engagement by the Tomlinsons?
Mr. Elliott was correct. The contract expired, so the Tomlinsons, who owned the property and authorized Brand to proceed in its behalf, took up the appeal.
So Brand Properties is no longer your client on this matter and no longer a party to this application?
No.
Okay.
I wouldn't say they're no longer a client, but they are not a party to this appeal.
Okay, this is, I'm looking here at the application for overlay district certificate of compliance.
Yes.
Dated at the bottom 11/2, stamped in as received November 8th. Who signed this
That was Michael Hoth with Brand Properties.
is Michael Hoth an officer of Brand Properties?
President, you have an affidavit.
Okay.
from-
Okay, so how do you explain the transition or your jurisdiction, if you will, to make a appeal on behalf of the party who's not the applicant?
Because the applicant was authorized by the property owner to pursue the application, and I believe legally both of them have the right to challenge anything that happens in conjunction with it. It could have been either or. Often it's the developer, sometimes it's the property owner, sometimes it's both.
But the owners didn't sign this and they're not named anywhere on
The
this.
owners don't have to sign that. The owners had contract at the time. The owners did have to authorize, I believe, the LDP, although I'm not positive about whether there was a signature on that. But it was filed with a deed showing who owned it and the like. It wasn't owned by Brand at the time.
Did Brand or the Tomlinsons engage any traffic engineers for this project?
No.
Did they consult the DOT, Georgia DOT, for DOT requirements as to being on a state highway, Peachtree Road?
They did not, but in one of the email exchanges that you were provided, David Cullison asked David Pelton, who is the DeKalb County traffic person, to look into that matter, and I believe David Pelton responded that there might be a limitation on a driveway coming directly onto Peachtree, but that was the only concern. So my clients did not, but it was done by the county.
Okay, I'd like to ask you some questions about the survey.
Okay.
Could you put it
Survey
back up?
That does
Apparently,
my part.
there's a survey submitted with your application for overlay compliance. That's the survey where you were trying to point out the two lots, one of which entirely was in DeKalb, one of which straddled the line.
Yes, that would have been,
Okay.
survey is flawed for it.
Are you familiar with
Is that what you're looking for?
yeah, is that in fact the only survey that was submitted with these applications to DeKalb County?
I know it is the only survey that was submitted with the application for certificate of appropriateness. I do not know whether there was an updated survey in this stack of documents down here. I can look if you want me to.
I might. I'm trying to make a new point that hasn't been raised by staff or DeKalb or anything else, but is in fact a code requirement. Are you familiar with 27381A of the DeKalb Code?
Absolutely, off the top of my head, I can tell you exactly what it is. No.
Okay.
Okay, clue me in.
Oh, come on, Kathy. 27381, let me get it. This is under the RM75 zoning classification, which everybody has, I think, agreed. The section starts 27376, that's set. 27377A is the one that says 18 units per acre.
Right.
If you go back in the same, what they call the same division, 27381A says that there's a requirement in the RM75 district that the lot area, that all lots developed with multifamily dwellings shall have at least 100 feet of frontage, not an issue, and a lot area of not less than 2 acres, and may be developed at a density not exceeding 18 units per acre. So there's actually 2 requirements, not less than 2 acres.
There's 2 acres there.
Excuse me, show me where on that plat it says that the DeKalb County property, the subject property of this zoning application, has at least 2 acres.
I don't know if it's on that plat, but it's on the site plan and everything else that was filed.
No, ma'am, it's not.
Want me to find it?
I do. Here's a full. Yep, I see that. That says parcel 1. There's 2. I'll help you out a little. That plat up there, you were kind enough to provide us a large version. I can actually read it even without my glasses. It says parcel 1, which refers to your straddling lot.
Right.
Parcel 1 area, 1.976 acres.
Right.
Parcel 2, your DeKalb County only lot, 0.793 maybe?
9.5, I think.
95.795, okay. So neither one of these parcels is the parcel that's the subject of this application for to DeKalb County for interpretation, and now in Brookhaven. The DeKalb County Brookhaven property, the property that you're seeking to get a zoning interpretation on, that you sought compliance with overlay on, is not drawn on this survey.
No, but it is drawn on the site plan as that a combination of the two lots.
My
We
point,
took some from Atlanta and some from the DeKalb and put them together and have more than two.
my point is simply this: how do you establish in your application to Mr. Cullison in the DeKalb County Zoning Department compliance with Code Section 27381A that the lot you're applying to rezone is at least 2 acres?
If you'll direct your attention, please, to sheet 4 of this document set, which is
Okay.
entitled Master Site Plan.
I've got, that would be these sheets.
Now look in the bottom for a 4. It's in the big set of sheets, but they're folded. They're in the binder, and it's a folded set.
They're
You're-
in
you're-
the binder. But is this the document you're pointing out that was in the application
Yes.
to, okay, let's take a look.
Under 1 or 2?
27B, that's what Linda's telling you.
So you agree that it has to be a minimum lot size of 2.0 acres?
2.04.
Was this submitted with the application for zone overlay compliance or with the LDP?
This was part of the LDP.
Thank you.
But
Okay.
now if you'll go and look at the zoning compliance exhibit, there is a similar site data summary. on the
What
upper-
page do you want me to look at on this?
On the survey? Which one are you looking at now?
Your package,
27B.
27B.
No. 27B.
You said page 4. This is not a survey. Page 4 is a site plan, not a survey. It has no boundary, meets and bounds showing.
I'm still showing the master site plan was filed as part of that application, and I'm looking at the same data summary. I don't know what you're looking at. It's up in the left-hand corner.
Sub-area 1, okay. Okay, this, but you said this wasn't submitted till the LDP application on November
There
30th.
was a separate one that was submitted with the overlay certification application. There was again one submitted as part of it's part of both.
Okay. Okay. I'm just trying to make the point that, and even in this one, it does state the cab area 2.04 acres, but this is not a survey, and I don't think it adequately certifies the acreage of the property without a surveyor stamp on it. Okay, next question. You showed us the board there with the green area being the proposed park.
Yes.
Are you showing any kind of access or road through that park?
No, we did the first time we went to meet with the neighbors on October 22nd, and that was something that was, well, adamantly opposed by some and wanted by others because it would have spread the traffic. Carl Westmoreland was of the opinion that we couldn't get permission to go through that lot from the city of Atlanta, so we took it off.
So where are your curb cuts and access for your proposed
The proposed
project?
access points at this point are off of Bel Air and Peachtree.
One curb cut on Peachtree. Have you looked at the code on that, on the access points?
What part of the code?
There are limitations on the amount of access.
Again, you're going to have to help me a little. I don't
Okay.
know the code by heart.
Okay.
I know that it was reviewed by transportation, and I don't think they had comments. And we do have access on the Peachtree now.
Is it your position that the number of current apartments on the current buildings that are there now, do you think there are 18 units or 24 units? I've seen alternate interpretations of that. Or 16 maybe. Was it 16? Ms. Dunleavy said 16 units an acre. Thought I saw in your materials there are 24 units an acre.
If I might interject, that my 16-unit assertion was based upon Mr. Jordan's affidavit saying there were 16 units currently on site, both the City of Atlanta site and the DeKalb site. That's where the 16 units came from.
24 is what my client's telling me. May have been some vacant at that point, I don't know.
Okay. That's all my questions. Anybody else have questions? I did.
Could you direct me? Yeah. Could you direct me specifically where in the overlay, where it states the density requirement that you're advocating on behalf of your client?
It doesn't. It is what is called a form-based zoning ordinance, which means, as Ellison said in his email to Carl, you go for the height, and you go for the design, and then what you can put on the property in park, you can put there. That's the type of zoning ordinance that it is, and that's the way it was interpreted in DeKalb. That's the gist of my argument. But it doesn't say. That's the problem.
Well, maybe a problem for you. But just because it's unfavorable doesn't mean it's unclear.
I didn't say it was unfavorable. It is unfavorable,
It is,
clearly,
well.
but it is also unclear.
Okay.
You want to take a question?
I have a couple more.
Go ahead.
If you and I are having a disagreement, Ms. Zickert, and I'm silent, if we were married and we were fighting and I was silent, if I didn't say a word, is that a conflict?
A what?
Is that a conflict? Are we in conflict if I'm silent?
I guess this depends on what you're being silent about. I mean, if I'm saying, Jed, I want you to talk more, and you're not talking, then yes, that's a conflict. I'm not sure what
You're citing the code, the language within the overlay compliance that says, in the event of a conflict, the overlay controls. Why is there a conflict if the overlay is silent as to density?
Obviously, is it Mr. Beers or
Byers?
Mr. Byers doesn't think there is one. Everyone who looked at this ordinance in DeKalb County, which was the point of trying to provide you with this data, does think so. And that's important in terms
Everyone?
of...
What do you mean by everyone?
Well, everyone who looked at it and said you can't tell what the density is.
The overlay is silent as to density. It's silent as to
Correct,
floor areas as well. So if you look at the DeKalb code, in these areas and the overlay and hold them side by side. Even in 27381 A and B, which I mentioned earlier in my question to you, the lot area, 2 acre minimum, there's no comparable provision in section 15 subsection 15.5 of the overlay. But there is a provision in the overlay subsection 15.5 on setbacks. So 15.5 in the overlay modifies setbacks. It reduces them, right? It doesn't say anything about lot area. So the overlay is silent on lot area. So everybody believes that there's a 2 acre minimum lot area for this project.
You are assuming that. We don't know because that question has never arisen.
Okay. Well, but code section 27381A.
And I agree with you, it says that, but you are assuming that that applies.
Okay.
And the same argument I understand that you're making now would apply to that.
Okay, you made the point of talking about the transitional buffers. So could you compare for me subsection 15.6 of the overlay with section 27383 of the DeKalb Code, which addresses transitional buffer zones?
RM75 transitional buffers are 50 feet, overlay is 30 feet.
So would you say that the overlay is less restrictive on that?
Yes.
Okay. All right. And the overlay calls for 6 stories as part of your, that's 12F of the 15.12F, and 27384 calls for maximum 4 stories in height. That's part of the zoning code. So here the overlay is more generous, right?
Right.
Okay, so let's look at a couple areas. There are a couple areas that are also silent. There's silence in the overlay as to floor area of the dwelling. And so 27385 would be your requirements for floor area of the dwelling because the overlay is silent.
Actually, I think you might look at the building codes if it's...
Well, the building codes may apply also, but the zoning code is 27385 and has floor area limitations. How does your project, what documents in the application submitted to the DeKalb staff establish compliance with 27386 of the DeKalb Code, which states that the lot coverage shall not exceed 35%?
There was an open space plan that was filed as part of the overlay certification package. It was repeated in the land disturbance permit set.
Howard, do you think that the lot coverage requirement of 27386, that the lot coverage not exceed 35%, do you think that was part of the package that went to DeKalb?
I can look through and look at the report from David.
I think you have to look at what was submitted, not the report from David.
Okay, well, what was submitted is my question. But
can you state again the section you're looking for?
27386 of the DeKalb Code, which provides for a lot coverage not to exceed 35% of the area. This happens to be another area where the overlay is silent. So, Ms. Sicker, would you say that that's still a requirement of your project, that it not exceed the 35%?
I don't think that your overlay is at all silent when it relates to lot coverage. There is a lot of discussion within the overlay about how the more open space you have, the higher you can go, the more dense you can be, and that kind of thing. So I kind of disagree with your interpretation that the overlay doesn't mention open space.
The overlay has a 20% minimum open space, public access open space requirement.
Public access.
Public access.
That's not on the property, necessarily. Public access would not, open space includes more than just publicly accessible.
Correct. Does your project include any public access open space?
I believe that it did, but if you let me look at the document, I can possibly answer that a
But
little better.
are you asking for any bonus?
We were not.
Bonus? Okay. My point to my fellow board members is that there are other areas that may not have been in the application, that the applicant may not have established compliance with all these requirements for overlay approval. And so lot coverage, I didn't see it addressed. But it's also another case where silence in the zoning code, silence in the overlay means that the overlay defers to the zoning code, the base zoning. Silence to me means deferral, not conflict. And so if the overlay doesn't cover it, well, there's still a law. It's called the base zoning code. And that applies both in density, floor area of the dwelling, and lot coverage minimums, or maximums, sorry.
Do you have any questions, Jeff?
No.
Okay. One question I have is in regards to the park. Who will retain ownership of that if this project is granted and developed?
We were willing to do that, or we were willing to consider making a donation. We've never got that far in the process.
Okay. But as it stands now, the property would still be held by the owner of the property as a whole. Is that correct?
I'm not sure whether Brand was buying that small. Yeah, I think so. Yes.
Okay. All right. And because that has separate tax parcel IDs in Fulton and DeKalb County, I guess this question would be more for legal. Is there a possibility that if this was developed and a park was placed there, but the owner of the property 5 owners from now decided that they wanted to develop that parcel, is there anything in the plans here that restricts them from doing that?
The Fulton County parcel?
Correct.
As it relates to the tax, it has 2 tax numbers because it's 2 separate counties.
Correct.
Right? The director at DeKalb put those 2 together and has noticed that, and it was his determination that as they were treated differently by the property owner in terms of purchase and sale, that they were in fact 2 separate properties. But nothing that we do in the overlay district, I can't direct as a city of Brookhaven or DeKalb County.
And feel free to dive in, Kathy, but I think, I don't know about the specific plans, but should that be chosen to be a condition of this, it could certainly be memorialized in a way where it would be binding.
And deed restricted or something.
Okay. All right. All right. Did anybody else have any other discussion? Any board members?
I have a couple questions. This is directed towards Mr. Kuntz and the council. It's my understanding that we're not necessarily required to look at previous cases or previous matters when making individual decisions. So I'd like you to just comment on that.
That is correct. The concept of precedent does not apply in zoning administrative decisions. This is the first appeal that has come in front of this board. This board cannot even have precedent as to how it's treated other appeals. And so it needs to treat this as a separate appeal. I can't speak to, and you can't speak to, what DeKalb County has done in the past. It's outside your jurisdiction to comment on their decisions. So the board would treat this as its own appeal.
And the second question is, could you explain to us exactly what our options are as far as motions at this point?
Obviously, there's one option is the motion to affirm the appeal, and the other one is the motion to deny the appeal. And for each of them, you would state a reason as to why you made that motion. They have appealed 3 specific things, and you can either separately talk about them, or you can deny on either one of them or on all 3 of them. But I would urge a detail in the motion as to why you would affirm it or why you would deny it. And obviously, potentially, you can defer it if you choose to, but the ultimate decision at some point would have to be either to affirm or deny it for whatever reasons that the motion states.
Anybody else have any discussion?
I have a question for Ms. Dunleavy. Ms. Zickert brought up the property you referred to as Alta Brookhaven. I think she called it the Wood Partners application. I believe I saw in the materials that their application originally came in June of 2012. And you mentioned that the overlay compliance was in July. So with the Brookhaven vote being this July 31st, do you think there's any distinction between that application, which was totally before Brookhaven was an issue, as compared to Ms. Zickert's position about manipulation and the terms she used were
backroom machinations?
Orchestrated appearance of impropriety when the Brookhaven vote was just on July 31. The Governor's Commission started business September of 2012, and there they didn't start talking. She said that her documents say on October 8th, Brands people, Mears and Hoth, first met with Cullison. It was pretty obvious Brookhaven was coming. They appealed this. They filed their LDP November 30th. The Cullison memo to Cornell was December 7th. December 13th, Cullison issues his compliance report. December 14th, they appealed. In fact, the Brookhaven swearing in of the mayor and city council was December 10th. So do you see any distinction here on this jurisdictional question between Wood Partners application and this application?
Unlike Ms. Zickert, I'm really not going to speculate in regards to the politics behind this. I think that it's very clear from the facts that have been put forward in the record that the Alta at Brookhaven was approved for compliance, and this is in Ms. Zickert's materials, July 27th, 2012.
Before the Brookhaven vote.
Before Brookhaven became a city. From what I understand and what I know occurred between July 27th and when this Overlook project came in. The Overlook project was first presented, according to Mr. Jordan's affidavit in Exhibit 24, 11 days after the Alta Brookhaven application was approved, and when after the City of Brookhaven vote had been taken. I really am not going to ascribe anything politically to that. From what my clients tell me is really, I think, what happened between the Alta Brookhaven approval and this project is that in the Alta Brookhaven project, nobody ever really questioned density. Nobody said, you know what, I think you've got it all wrong. It just was overlooked until the Overlook came along. And then when the Overlook came along, Mr. Scher, as he has testified before you all, he wasn't sure that he could wrap his mind around the notion that somebody would have allowed a 176-unit apartment complex at the corner of Bel Air and Peachtree to come in, that there had to be something regulating density. And so I think Mr. Scher, for the first time, raised that issue with DeKalb County. And keep in mind, DeKalb County had only looked at 2 multifamily projects in the overlay before this. And none of those projects was density ever challenged, questioned. Did they even go back and look at how their ordinances were drafted and fit together? And I think that's the difference. There may have been some political stuff going on. I don't think there's any dispute that Overlook wanted to get their approval before Brookhaven got its hands on it. But I think the real difference was somebody all of a sudden put the brakes on and said, hey, let's take a look at what the overlay regulations really provide. And that's when the rails, the wheels came off of the Overlook project, because somebody challenged it and said, look at the clear language of the ordinance.
Wood Partners overlay was approved December 6th. There was a second review.
That's after Brookhaven, and that's what the colloquy between Carl Westmoreland and David Cullerson was about. Are you going to apply that rule to me?
Council, my understanding is that this board has the power to make any decision that the staff could make. That we stand in the shoes essentially of Mr. Cullison, Mr. Cornell, and basically can just make a decision one way or the other, whether they're right, wrong, or indifferent, without any reference to precedent, is what you're saying. We read the code and we interpret the code, and that's our job.
Yes, so you read the code and you determine as a body whether in accordance with the code, the decision made, the underlying decision made by the DeKalb County official was correct pursuant to your interpretation of the code. Yes, the code of DeKalb County in this particular case.
Either error or an arbitrary decision, or it's fine. We have to find error or arbitrariness to overturn.
There's a constitutional arbitrariness, of course, that Ms. Zickert has filed, and that's beyond the purview of the board to decide constitutional issues, but you can decide as to whether the decision of the DeKalb County official was in error in accordance with the interpretation, your interpretation of the DeKalb County zoning ordinance as a whole, yes.
I'm unclear whether the question before us is, whether the first question is in fact before us, was the application in compliance with the overlay, the original certificate for overlay compliance. Ms. Zickert said we don't have to decide that. Even Ms. Dunleavy didn't bring it up. Is it, Mr. Chairman, what do you think? Do we decide the first question of was the application for certificate of compliance with the overlay, their failure to approve it, is that something we're affirming or denying?
If you look at Ms. Zickert's original appeal of administrative decision, she lists 3 issues that she is appealing.
And the first one is that one, correct?
The first one is whether the DeKalb County official was correct in his determination that the application was in fact incomplete.
So that original appeal statement supersedes her later written submissions and her oral statements tonight?
They don't supersede.
I'm asking.
They work together. Her arguments all go back to her 3 issues, and you would treat her arguments as speaking to the 3 issues she initially appealed. The appealing issues are A, whether the required elements of the application for the overlay certification were submitted, i.e. whether the application was complete. B, whether their determination that the applicable density was 18 units an acre was correct. And C, whether the boundary line to be utilized for the purpose of determining compliance with certain provisions of the overlay district is the boundary line of the overlay district or the boundary line of the alleged property line of the property, which the DeKalb County official also said have disputed in terms of the boundary lines as well.
I'd like to make a motion, Mr. Chairman.
I don't think we're through with discussion yet.
Okay. I make a motion to close discussion.
I've still got some discussion.
Okay. Not hearing a second.
Second, I believe Ms. Zickert wanted to have a response to it, and I don't mind if she would make her statement.
That is how the city characterized.
That is how the city characterized our appeal. We did not think we were coming to the city when we filed it, and we did not think that the city would be interpreting its rules and applying it. We thought we were appealing 3 issues in DeKalb County, and it was 3 only. It was whether the density is limited, whether the height plane should be measured from the boundary line or the city line, and whether the buffer should be measured from the boundary line or the city line. We thought we were going back because the completeness of the application is irrelevant. You can supplement. You can file over and over and over again. So we were trying to resolve those 3 issues and then would have come back in and done what we needed to do. If you think there's open space information missing, we would have supplied it. That's the whole point of the review process. We couldn't foresee that we were going to be pulled out of there and sent over here.
Would you be willing to waive or forego your jurisdictional arguments and agree to let Brookhaven hear this case?
No.
Okay.
No.
I just asked.
I've got a couple more questions, one for each of you, and it probably won't be popular in the crowd, but you've both mentioned the possibility that you're both open to a deferral. There are a lot of trees that have died in order to provide this material to us, and a lot more have died in the last 24 hours that we need to review. That, you know, I guess my question to both of you independently would be, if this case were deferred for 30 or 60 days, do you think that both sides would benefit in coming together, and would you be willing to facilitate that to possibly work on a compromise?
I'm willing to try that. I've done that with Cecil before. I've done it with Linda before, and I've done it with Marie before. So I'm certainly willing to give it a shot.
Okay.
But I think it would probably take the full 60 days is my guess, because you're looking at plans and revisions.
Right. I understand. Ms. Dunleavy?
We're certainly willing to discuss with Ms. Zickert any grounds for compromise. As Ms. Zickert pointed out, I think you have 60 days. We're certainly willing to discuss it. Can we reach a compromise? I guess that remains to be seen, but we would not object to a deferral for that purpose.
Okay.
I would only ask that if it is going to be deferred, I would myself, quite frankly, like the benefit of being able to submit something in response to the binders that I received from Ms. Zickert yesterday. Within reason, I wouldn't submit additional binders.
As would I with regard to the materials from tonight. And I also have the original affidavits, because we couldn't get them signed and get them to you, so I need to put those in the record.
Okay. All right.
Mr. Chairman, are we going to discuss your question?
Well, we're still having an open discussion.
Okay. You know, I'm concerned about deferral. I'm not sure it makes sense because the issues are fairly cut and dry. You know, the issue is whether the zoning ordinance at 18 units per acre is the law on this case. And there's been a lot of question. Well, what does the overlay say? Most people agree it's silent on density. You know, if I thought that the applicants could settle with the opponents at 24 or 30 units an acre, you know, maybe deferral would make sense. I think the point is that, you know, if the zoning ordinance at 18 units per acre survives the day and is determined to be, whether it's by us or by a court, that's the law, then that puts the applicant into a rezoning process. Is that correct? To come back for more density if we decide on density and then the court affirms, the Superior Court affirms, whatever the courts do, whether she appeals that, I mean, that's a lot of litigation for the city, a lot of expense for the city, but to get more density, if it were determined at 18, wouldn't she just have to reapply a new zoning case and go through planning council?
If it is determined that the underlying zoning density applies, then the only way to deviate upward from that would be through a rezoning, but that's at the end of a, as you said, a decision chain that would lead us to that.
Right. So, I mean, to me, it seems like, you know, a pretty cut and dried issue on that particular point. I mean, I'd consider calling these questions individually and voting on them individually rather than deferring them and seeing what happens tonight. You know, whether we, the three, we could even defer the question of was there, her first submitted application, which she's asking us not even to answer, was the certificate of compliance application properly acted on? She says we don't have to hear that because she can amend and amend and amend. So
I just want to say that if you defer, you have to defer the whole thing. You can't vote on
Can't vote on
you can't
part.
vote on half a case today
Okay.
and defer the rest. You need to defer the entire case if you're going to defer.
I am simply suggesting that we save the city money in litigation expenses if this can be resolved, and I mean that sincerely, because no matter what happens tonight, that's where it's headed. It would be nice to avoid that if there's any possibility.
It'd be nice to avoid litigation. I agree. You know, I read most all your material. I read most of this material, and you know, the LCI ordinance in 15.1 talks about a more dynamic mixed-use community with the character of a multi-story urban village. It also talks about development of neighborhood-oriented facilities. It talks about protection of established single-family neighborhoods. That's in 15.1. We're interpreting the overlay and how it complies, and 15.2 of the overlay says that the purpose and intent of the Brookhaven Peachtree Overlay District is to implement policies and objectives of the comprehensive plan and zoning ordinance within the overlay district. The comprehensive plan says 8 units per acre for this property. The zoning ordinance says 18. And the comprehensive plan calls it suburban at 18 units per acre. The zoning ordinance refers to that as commercial residential corridor. That sure sounds like exactly what this is. The overlay also says in 15.2F, to design and arrange structures, buildings, streets, and open spaces to create an inviting, walkable, mid-rise, human-scale environment. And I personally don't feel that this application creates an inviting, walkable, mid-rise, human-scale environment. And I of the same section says, to ensure a proportional relationship of surrounding buildings with respect to general spacing of structures, building mass, scale, and street frontage using techniques to achieve compatibility, and then it goes into these sections. So, you know, I just personally feel like I think this should be denied, and it's totally out of character with the overlay, both the spirit of it as demonstrated by these preambles and with the actual code itself and the interpretation of things like boundary line or property line. You know, the code in 15.6, the paragraph that brings you into the transitional height plane and transitional buffer requirements. It talks about boundary lines. The term used in that interpretation, if I have to interpret that code section, uses the word boundary line. You know, clearly the DeKalb County, Fulton County border is a boundary line. It's not a property line. The property line, as you described it, goes around the perimeter of the property. I understand property line, but the code in 15.6 and that transitional height plane talks about boundary lines, and that it's both a boundary line of the county and a boundary line of the overlay district. So I feel that's a pretty fair interpretation. I'd like to see us vote on the whole thing tonight.
Is there any more discussion among the board? Okay, seeing as how there's no more discussion, I'll entertain a motion.
I'd like to move that we defer.
I'll second.
Okay. So the motion, as the chair understands it, is to defer item AA13-031.
Discussion on the motion.
I was getting to that. Is there any discussion on the motion?
How long?
The deferral period. Defer to a date certain.
I think on that we should not defer to the...
Let me get a... How long are you recommending?
I think both of the women indicated it would be 60 days, so I'd be prepared to accommodate them.
60 days is the limit of our decision-making authority, And the problem with 60 days is
Let's get into the discussion portion of the motion. Okay.
Well, 60 days is not, is too much.
Okay.
I don't want to paint us into a corner, but I want to give them an opportunity to...
All right. So the motion, as the chair understands it, is that there is a, we are going to defer case AA 13-031 for 60 days. The motion's been presented and seconded. Let's have discussion on the motion of the deferral.
I'm against deferring it to a regularly scheduled meeting because of the backup of other cases we have at regularly scheduled meeting. We've heard before from staff that we have an overabundance of cases. So I think if we defer, it should be 45 days. We should have a special called meeting in between the next regular meeting, which is 30 days out roughly, and the 60-day, which would be the second out regular call meeting. I don't think this should be put on a regular call meeting with 5 or 11 other applicants on the same thing. So I'm just making that comment for your consideration if anybody wants to amend the motion.
Okay.
I'd certainly be open to that.
You can accept it. Waiting on it. Oh, sorry.
45 days would be on Sunday, May the 5th, so if we don't defer it to a regularly scheduled meeting, we would need to defer it to a date certain, so we need to pick a date.
Just FYI, we don't have any applications yet for the May meeting, for the regular May meeting. You are correct. We have an over an abundance for the April meeting. I'm working my way through them as quick as I can.
Some of those could get deferred.
It's possible that some of them could get deferred, yes.
And the deadline for the May meeting to apply is April 1st?
It is Monday, April 1st.
Right. So right now the motion as it stands is for a 60-day deferral. How would we go about if someone wanted to amend that?
They would just offer an amendment to the motion to defer to a date certain, and that would need to be seconded as well.
Okay.
So they would need date certain.
45 days would be around May the 5th. That's a Sunday. If you want to defer it to days on that first week of May, from the 6th to the 10th. I don't do, what days are our council meetings? Tuesday?
But there's not a council meeting that week.
Yeah, there's no council meeting. So
First regular council meeting in May is Tuesday the 14th.
at court, night court.
Planning Commission meeting that first Wednesday.
Night?
Yeah. No, the first Wednesday.
Wednesday, May 1st is Planning Commission.
On May 1st. So we could, I think available dates would be either Tuesday, May 7th evening, Wednesday, May 8th, or Thursday, May 9th, unless we have any other conflicting meetings, which I don't think we do. So most of that week at night at this point is available in terms of conflicts.
There's no court in session here.
Court's on Friday night?
Fridays, Tuesdays and Fridays.
Tuesdays and Fridays.
Wednesday or Thursday.
So.
Do you want to make an amendment to the motion?
I'm not in favor of the motion, so I'm not going to offer it now.
Mr. Chairman, prior to the amendment to the motion, I'd like to ask both parties, you had previously stated that you would need the full 60 days. Would 45 days suffice?
I would prefer the 60, frankly, but I understand what he's saying. If you could push it towards the 55 instead of the 45 and just pick the date, that would be fine. I'm also not sure.
Also, if both parties are willing to waive the 60 days, we can go beyond that.
I was going to suggest that, and I'm also not sure we have another public hearing. Quite frankly, I think the public hearing may be done, so it's not like it's going to occupy a lot of your time. You're just going to have to make a decision.
Right.
So
Okay.
I think that's correct.
I just want to say I didn't really request 60 days. I'm not necessarily sure that we need 60 days. You know, if we're going to push it out that far, quite frankly, I would prefer 30 days. simply because I
That's
think it's
definitely
going to
not
be,
enough.
we may not come to a resolution, but we will know whether there's any traction in regards to it. Because my understanding is you want this deferred not only to review the materials that have been submitted, but you want the parties to get together to see if there's some room for compromise.
That's really.
I have a pretty good feeling that within 30 days, we're going to know if there's any traction with respect to a compromise and that there's not much need to push it out to 60 days. I would prefer a shorter time frame, quite frankly.
My only concern is in drawing up plans, because if we can come up with a compromise plan, that can take a couple of weeks, so.
If we come up with something in good faith, then we can discuss what Mr. Feldman has put forward in terms of waiving the 60 days. I just don't want this necessarily to drag out 60 days, so we can just come back and report we made no traction, we had one meeting and we were done.
We're just too best at 15.
Yeah, I think that since we do not have anything on the calendar for the May meeting at this point in time, at this point, and since there will not be a public hearing portion of it, you know, we'll be able to determine if a compromise has been reached, and we'll also have a little bit more clarity in our minds, in my opinion, of which direction we need to go with this case. So I personally don't think we need to amend the motion to change it. I think the 60 days is sufficient for both sides.
I don't know if that's 60, but the date certain at this point would be Wednesday, May the 15th, which coincides with the regular May meeting of this.
And why is that important?
Why is
the 60 day? Yeah.
There's a section in the code that reads that after the public hearing is held, you don't need to make a decision on that date, but you're supposed to make your decision within 60 days of that date.
Okay.
However, if the parties involved agree to amend that 60 days with their consent, you can defer your decision to whatever date you choose.
Would May 15th fall within that 60-day window?
It's less than 60 days.
It's less than 60 days.
Mr. Chairman, what are we hoping to accomplish in this deferral?
To take in the new information that was presented to us tonight, and to get, you know, the possibility of reaching some sort of compromise.
A compromise. What I see is clearly the issue here. The boldest issue is density. And we are looking at 18 units per acre versus what is proposed at 176 unit apartment building. That's a pretty large disparity for to compromise to be reached within 60 days. And I don't believe that we're going to be able to fill that gap in 60 days. And I think that the issue at hand is very clear. I don't understand what we're going to be able to accomplish with the deferral.
All right, is there any other discussion on the motion that's on the floor?
Has it been amended or not?
It has not been amended. So the motion on the floor is to defer this item AA13-031 to the regularly scheduled May meeting, which will occur on May 15th. All right, and since we've closed discussion on it, we'll go ahead and call for a vote. All those in favor of the motion, please signify by raising your hand and saying aye.
Aye.
Aye. All opposed?
Nay.
Let the record reflect that the motion is passed. Before we move on to item F, the public discussion, I apologize for not making an announcement earlier in the evening. But tonight, our new Community Development Director, Susan Cannon, is here. She'll be starting next week. Monday, I believe. Welcome to the jungle. All right. Now we have the public comment section of our meeting before we adjourn. If anybody would like to come up to the podium and make any comments, please feel free to do so at this time. Seeing as how there's no public comment at this time, I hereby adjourn this meeting.
You can't be. You had to give 30 days. You have to give time to the